That's right, everybody. We're back here. Today is May 20th, 2017. We're here live at A&C Firearms in Heidenhammer. And if you go to my Facebook page, and we're streaming live, and we finally got him here. Here he is. Say hi, Ross.
Woo! Yeah, I finally made it. I don't know how I got through Rogers without a ticket, but I got through there. So
you were going too fast. They couldn't catch you, man.
Some logistical miscommunication here today, but we're
Don't worry, we're professionals. We can handle it. But we got a lot going on. Ladies and gentlemen, we're here live at A&C Firearms in Heidenhammer. You need to come on out and say hi to the crew. At 12 o'clock, I've got a free handgun familiarization class. It's a shortened version of what I do. So if you've got a gun that you don't know what you're doing with, if you want to get a gun and you haven't a clue what to do, don't know which one to pick, now's the time to come out and see us. Lots of guns to pick from. I can show you. I've got these cards that tell you what to pick and how to pick it. And just come on out here. So we're going to be here live till 12 o'clock. Come and say hello to everybody. And after that is that free class. Now, Ross, for the last 2 weeks, we were talking about Penal Code 931, self-defense. But in it, there's terminology that says deadly force. Then I read Penal Code 932, and it's talking about deadly force, but then it says if you use force or deadly force. And I understand why they do that in this penal code. But why do they even bring up the terminology of deadly force in a penal code that is meant for force?
The answer to this question is really simple. It's very quick. The deadly force statute, you've got to have 931 as a prerequisite.
Yes.
So it references 931. And so the 931 statute is simply saying, because if somebody's going to have to use deadly force, then 931 is going to have to apply as well. So it's good that 931 uses it, but it can also cause some confusion. I see there's the same problem, if you want to call it a problem, with 941 and 942, which is the defense of property.
Right.
And it's simply the answer is they reference each other. They work off of each other. You have to have one before you have the other.
I understand that. I can see like 3.2 feeding off of 3.1 because it's building up, but it just seemed like it was causing confusion. Well, can I use deadly force? But no, I'm in 931. Can I use deadly force when it uses the terminology? But in reality, it's just for force. So it just
931 is making clear. No, 931 applies in a deadly force type of situation too, because you have to meet the standards of 931 before you ever get to 932. And so I think 931 is clarifying that by including deadly force. The legislature just doesn't want there to be a situation in a court where they say, well, 931 doesn't mention deadly force at all, so why would we, if there was ever a conflict, okay, even though 932 says that 931 is a prerequisite, if 931 didn't, reference deadly force, and there was something in there you wanted to use to argue to the jury, or, from the state or the defense side, right, the other might be able to make some argument, well, the legislature didn't mean for 931 to apply in a deadly force type situation.
So deadly force terminology in 931 is like armor all the tires or icing on the cake. It's just getting you set up for 932 as it comes.
Exactly.
Okay. You got stories to back that up?
No, I mean that is the most logical. I mean, okay, so 941, 942, Lebo versus State. A bull had crossed over and gotten on Mary's bull had crossed over and gotten on Mr. McNeil's property. And Mary wants to go get her bull back. And she says, well, I'm just going to go get him. And McNeil says, well, you left the bull out there now 3 months. I think you're going to have to present me evidence that of which bull is yours and which bulls are mine.
I think that's bull.
And yeah, he was being kind of a prig maybe. And so she goes and gets some like a 70-something-year-old guy, and they go out there, and this guy named Lunsman is the older gentleman, and he supposedly was purchasing bulls and working the bulls, and so she gets him to go out there and point out the bull, and that's what he does, and he starts opening the gate and going in there to get the bull. Well, McNeil comes out, and I think the case is a flying tackle. He makes a flying tackle of Mr. Lunsman and ends up basically knocking one of his teeth out when he hit him from the impact, and then the old man ends up kind of have to have shoulder surgery, and it goes to trial, and it was presumed, and I actually wanted to talk about, because I listened to last week's show with Rick, and a caller, Mr. Johnson, called in and talked about, what if a guy's in my yard? A police officer should not have ever told him that he can just blow his leg off with a shotgun. And I don't know what officer that was, but that was definitely not a very responsible thing to tell anyone to do. I want to point that out. I'm glad he didn't say who the officer was. I don't care. Don't ever listen to an officer if they're telling you to actually blow somebody's leg off. Okay, so but this is sort of similar, because we were in a situation where he was saying, well, I won't, because this Mr. Johnson was saying, I won't kill him, I'm just going to blow his leg off. We said, if you have serious bodily injury, it's going to be presumed that you use deadly force. And that's exactly what Lebo versus State said. Okay, it said an individual who causes serious bodily injury necessarily, words mean things, necessarily uses deadly force. And so they were saying they used deadly force against this Mr. Lunsman, and so he had to go under the 942, and he was trying to argue 941, and he's saying, you made the jury assume there was serious bodily injury because you went under 942, when it was a real question whether this old man was really hurt. Other than, it's okay, bodily injury was one thing, serious bodily injury was another. Okay, and he was saying he may have been injured, okay, but I get to use a different set of standards under 941 for defense of property as opposed to 942. So by submitting 942, you made the jury think this old man had serious bodily injury.
You said something just a second ago, and I say this all the time, that words mean things, punctuation means things. You know what I learned from you and Rick? Words and punctuation don't mean squat. It depends on the attitude of the jury, the judge, what the judge wants to show. It's just like, that's why I think this segment is so good, is because you try to teach law in black and white and say this word means this and the comma means this, it's a whole new thought, but in reality it doesn't, and you show it over and over and over again in these cases.
Well, it means something to whoever's making the argument they need to make.
But
how about that?
It needs to mean everything to me if I'm the one at court trying to get out of something. You know what I mean?
It's like the Alice in Wonderland, the egg, the Humpty, when he's talking about words or what I think they mean, words or whatever I say they mean, and Alice is basically like, so.
Sounds like it's coming out of a 1984 novel.
Yeah, I mean it's Alice in Wonderland. It's at I wish I could remember the quote, but yeah, that's what we come from. But I was going to say about Mr. Johnson. So again, either one of these situations. So if you're going to use a gun, right? We've already said that the definition of a deadly weapon is gun, firearm. They define it as a firearm or something else that is in its manner of use can cause death or serious bodily injury. And so if you're using a gun, it's going to be seen that you use deadly force. The other thing is, if you cause serious bodily injury, which is protracted injury to a bodily member, which is your leg. If you blow his leg off, that's serious bodily injury. So in either situation, you're going to be presumed to have.
The camera, the girls want to see.
You're going to have to use. You're going to be presumed to have used deadly force and a deadly weapon at that. And so there's going to be a problem, because we've talked about firearms are hot. We've talked about when you're presumed that you'll be able to use deadly force. And if they're using force illegally to enter or remove you from your property, that's your home, it would be hot. It's a home, office, or your car, your transportation. Okay, and then there's got to be aggravated kidnapping. Okay, so we're going under arms. Okay, there's got to be robbery, murder, or some kind of sexual offense. Okay, and if you don't get one of those, you don't get the presumption. So right now you're telling me that he's showing up at your yard in daytime and you're just talking a bunch of mess to each other. You don't like each other yelling. So you're going to have to go under defensive property. Well, is deadly force necessary to, keep him from trespassing? Right? You're not going to win that case. Right? Do not blow his leg off if he comes talking mess. Now the property codes, I wish we would talk about defensive property more, because it allows more, it's a little bit more broad in being able to use deadly force. Of course, you've got to get more, there's more subsections that you have to qualify under, but you could actually use deadly force in certain situations, which is why the defendant in that Lebo case was having such a hard problem, because he didn't fall under any of the presumptions. And so it was nighttime theft or nighttime criminal mischief. So if he shows up at your yard and he's talking a bunch of mess, and maybe you feel like he's going to commit theft at nighttime, or he's going to commit some criminal mischief at the nighttime in your front yard, I think then you are at least in a better situation to blow his leg off. Okay, but I would never advocate that.
Terminology, my gosh. Let me read you a story here, and tell me what you think about this. I just read it as one of these fast true life stories.
How about the case you just read about the woman giving her husband the? Oh, that was great.
That was great, wasn't it?
Yeah.
That's teamwork right there. Lady helping her out her man. But let me read this story about this guy blowing somebody through the door.
Oh, I heard that case. Hey, go ahead. I'm sorry.
Okay, here it is. Alerted to someone slashing the tires of his boat carrier, a Centennial resident went to investigate.
Oh, really?
He was confronted by a knife-wielding man who rushed at him. The homeowner retreated into his home, picked up the pistol, and called police to report the incident. When the vandal attempted to break into his home, the homeowner fired through the door, whereupon the vandal returned fire through the door. Okay, so here you got the guy slashing.
No problem in that case. No problem in that case. He already had a knife out?
He was slashing the tires, right?
He already had this knife out.
So the homeowner runs into his house, the door is shut.
If it's at nighttime, he's already causing criminal mischief. But if he runs in and the guy's trying to get in the door, there's no issue there with me. Even if they're mildly unreasonable, district attorney is ever going to charge you with that case. The code says if they're attempting to enter, right? If they're attempting to enter your home.
There you go. Especially under those conditions, you're good to go.
I think, but now you may have a problem if you end up shooting the wrong person
because you don't know what's on the other side of the door.
That's what we really get into, and it's going to be
reckless injury of an innocent third person.
Yeah, that's where we were really getting into the door thing. How do you're going to have a hard time explaining if you shoot your 12-year-old niece.
So what it boils down to, because we're getting close on time, what it boils down to is it may allow you to do certain things, but you always got to worry about the unknowns, and that is, where's the bullet going? What am I trying to say here? Even though you may think you're right, there's always room for error that you may not be thinking about. So just don't go into a situation thinking, well, it says it here in black and white. There's so many different aspects that can distort it and make it look bad for you, right?
I mean, that's the law, yeah. But I do want to clear.
I feel great now.
I do want to clear up. There was a gentleman too. We didn't get his name, and you had a lot of things to go through, and he called you during a time we didn't get to his question until late. It wasn't me there, but he had said again, can you use your license to carry his rifle? Again, I want to make clear. Yes, there's certain places you cannot carry your firearm, but you don't need your LTC, your license to carry, just to carry the rifle. So it is the license to carry is to carry your pistols.
Strictly for a handgun.
Yes, and I wanted to point out, some people have. We talked about devices, and I was asked, could a dog, a protection dog, ever be a dangerous device? I mean, you cannot use a device that has a reasonable likelihood of causing death or serious bodily injury.
Well, an attack dog, I would think, has got a reasonable case of causing death.
Okay.
So how do they get around that?
We said, I think under most circumstances that's not going to be a device, but I was really asked, could the possibility arise? So we didn't really get into every scenario, and I've had a couple people kind of like, well, you didn't talk about this. So I want to make sure everybody knows. That's what I said. Under most circumstances, you are allowed to have a protection dog, and actually the Health and Safety Code, Texas Health and Safety Code, Title 10, it talks about animals, and it's Chapter 822, Regulation of Animals. This
showing it in the camera. All right, now you got it.
So this section talks about when you're going to be in trouble if your protection dog hurts somebody, and you're going to see a lot in there, especially it even talks about the dog being justified if they cause serious bodily injury or death to a person while they were committing theft or some kind of assaultive offense against another person. So even dogs, I kind of got goosebumps when I read that, because I went through the whole thing and made sure that I didn't say anything that was stupid.
Wait a minute, say that again now?
So the dogs themselves get their own justification, right? They have their own justification defenses, and they get to avoid being put down, and the owner is off the hook when they're acting in defense of persons.
Wow.
Right? And so the code allows these dogs, right, to show their loyalty. And it was kind of a good moment there, I felt like, from the legislature standpoint. But there are some gaps. And so, yes, I still stick with what I was saying. It is possible that a dog could be a device, and you could be charged for that as well as something else under the Health and Safety Code. And then I was going to talk about, you had a story last week about when you were walking in New York and you opened your trench coat because you saw two guys approaching. Two groups. They split into two groups.
That's right.
And you showed your pistol sort of as a threat, as a justification threat. Right? And there was a funny case, a new case that came out, Penal. He kind of had a fit of road rage, and him and another driver got into it, and he was probably in the wrong here. He was being a little bit unreasonable, and I think that's why he got charged in the first place. But he walks over to the other driver, and this part, could be believable to some degree. The other guy's like reaching for something. Well, Penal kind of pulls his shirt tight and pulls it up just enough where you can see the bottom of the pistol in the holster. So tell that guy, and he says, "If you do it, you're dead." And he ends up getting charged with that threatening display of a firearm under the 42-8, disorderly conduct statute that we talked about a few weeks ago. And the reason I mentioned that case is because, under the sections that don't, on the license to carry, you're not supposed to just display your weapon, even with the license to carry. A lot of times, even open carry in some places, you're even if it's in a holster. Okay, and there's a couple sections, and I don't have those on me, but there is a couple sections when you can't show your pistol. And so this case said that displaying your firearm was more than merely showing that you are armed, and it's more than merely showing that you have a pistol in your holster. And so it doesn't make much sense. It doesn't.
Let me go through a scenario here. You're bringing this up here, and I'm saying a guy comes up to me, and I think he's going to cause harm, and I flash my gun, Penal Code 904, like that guy did, and now he's getting in trouble for what reason?
So, like, for instance, if you were at a college campus, you may be able to have your concealed weapon, but you cannot display it. It says you cannot display it. You cannot, even if it's in a holster. As opposed to where you can open carry in some spots, you couldn't carry on a college campus.
So if something's going down, and I pull it out, and I was able to stop the threat from shooting mass people, but I displayed my gun, I'm in violation?
No, I'm not saying that at all, but I'm saying that you're already starting to get ambiguities because you have this one case under the disorderly conduct statute, and they went into this long spiel about what is and what is not displaying a weapon, and he's saying, I did not display my weapon because, like, by what you're saying, right, I only pulled my shirt back like this. And he was saying he used a justifiable threat as force. And the court's saying, no, you didn't use a justifiable threat because you didn't even display your firearm.
Okay, so what you're doing is you're confirming what I've been saying. And that is, even though you read it in black and white, it doesn't mean squat, because it all depends on the personality of the jury, the attitude of the judge, so on and so forth. So you just got, knowing this, a person carrying a weapon, knowing this, saying, I got the right, but in reality, I don't know, they may think twice before they do something stupid.
Look, so he like you, showed his weapon, basically, but he didn't as fervently show it, I guess there is...
I did it with class too, man. I said, come on.
And see, he more pulled his shirt tight and lifted it up just enough where you could see part of the gun in the holster to show him. And he said, don't you do it or you're dead. And so that was like a threatening display of a firearm under the disorderly conduct statute. Okay, so, but they talked about what is a display. And then so when you look at the display under the license to carry rules that don't, it says whether it's holstered or not, you cannot display it in a place on this campus. So they said he wasn't entitled to a justification defense, right, for displaying a firearm because he didn't ever display it, right, when the license to carry clearly says, like, even if it's in a holster, it's being displayed if they can see the weapon. And so I'm just like, so now somebody, I guarantee you, if they're going to see this, and somebody's going to be charged with displaying a firearm on a college campus or something, that lawyer's going to pull that case, right, and say, that court said, it's not displaying it, right? It's not displaying it when, just because it's in your holster and you can see part of the weapon.
Okay, here's what I want you to do. They got a fan club going for you. All the girls got a fan club going. Yeah, everybody see Ross here? Ross, tell everybody how they can get a hold of you, because what you're talking about, somebody sooner or later is going to have a case, and they're going to need you, sharp as a tack, who've got all this stuff in their brains and know what to expect, and you can be there to defend them. Tell them how they can get a hold of you.
105 East Main in Cameron. They got a milk cow on the side of the building. It's a painting. Come holler at me. My number is 254-605-4140. That's 254-605-4140. You can also call my cell phone 455-0569, 455-0569. Don't call me today because I'm going to the ZZ Top concert.
I was going to say, man, you look like you're a little bit under pressure wanting to get there.
No. And then Benton at Watson.legal. That's my name, Benton at Watson.legal. I'm glad to be here. Thanks for waiting.
That's no problem. Now, are you going to be able to stay? Because we've got the rest of the show going on until 12, and about 11:30 we've got, who knows what's going to happen. When we're talking guns and all that kind of stuff, we might put you back on the air. Can you hang out? Or do you got to go?
Yeah, maybe. Yeah.
All right, if you can.
Let me check it.
No.
Yeah.
I'll tell you what, Trey. Let's take about a real short break, and when I come back, we'll go over show highlights.